Welcome back to Educator.com. Today we're going to go over the Bill of Rights Part 2. So in the previous lecture we went through the first 5 amendments, and we're going to finish off the rest of the Bill of Rights with the 6th, 7th, 8th, 9th, and 10th amendments to the Constitution. So in today's lesson overview, we're going to review the amendments 6 to 10 of the United States Constitution. A quick overview of what these 5 amendments are. The 6th Amendment, you have a right to public and speedy trial. That's the 6th Amendment. The 7th Amendment, you have a right to jury trial in civil cases. The 8th Amendment is a right against cruel or unusual punishment. The 9th Amendment is that unenumerated rights still belong to the people. And the 10th Amendment is that power is not granted to the national government is reserved to the states. And so in conjunction with this, what we did in the previous lecture as well, we're going to examine key court cases that further clarifies the rights given to the American people as interpreted by the Supreme Court. So it's probably a good idea that before you take this AP exam, be able to associate at least one amendment to one court case. Obviously, if you have like 5 court cases per amendment, it's much better, but at the minimum, learn one court case established with one amendment and be able to explain what that court case has to do. So in this lecture, hone in on at least one of the court cases, try to understand its content so that in the case of an FRQ, you can dig back and use some of these court cases as references. Remember, this is not a constitutional law test. You're not going to law school here. These are just basic facts that you want to know in applying, some of the Bill of Rights, some of the rights found in the Bill of Rights. So it's not an extensive summary that you have to know. Literally, it's just maybe a couple of phrases or a couple of judicial precedents that are set within a couple of court cases that you want to be sure to know. Okay, the 6th Amendment. Let's go ahead and read this entire 6th Amendment in its original writing here. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, meaning you can't be randomly imprisoned, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And so the 3 court cases that you might want to keep in the back of your mind with the 6th Amendment is Barker versus Wingo, 1972, Shepard versus Maxwell, 1966, and Powell versus Alabama, 1932 here. So what are some summaries of these court cases to further clarify this right to a speedy and public trial? Well, in Barker versus Wingo in 1972, basically, what does it mean by speedy? I mean, is it a month? Basically, the general rule of thumb is that everything should take place in less than a year. Again, there are some extenuating circumstances. If there's a change in venue, for example, if you're a famous person and, getting a jury of your peers might not be possible in a certain area, so you go to another area, that might take more than a year. And again, if the defendant consents to this and then later claims that he didn't get a speedy trial, then the judge would rule in favor of the prosecution. And the degree of prejudice caused. So these are all grounds for dismissal in the case that an individual invokes his 6th Amendment right. So yes, you do have a right to speedy and public trial, but in some cases, if there's a delay for reasonable circumstances, then that is allowed by the court. Shepard versus Maxwell basically said that the right to a public trial is not absolute, so limitations can be set in place. So if for some reason, again, the individual is too famous, or the judge issues that a public trial is not maybe in the best interest of everything given the circumstances, then that right to a public trial is not absolute. So there can be certain circumstances where the judge restricts access to the public. And in Powell versus Alabama, this was in 1932, the right to counsel, whether requested or not, in murder cases, in this particular court case, an individual has a right, even if he doesn't necessarily request it. If this person, maybe doesn't have the mental capacity, Powell versus Alabama basically established that, you have a right to counsel if you're accused of murder. Okay. The Seventh Amendment to the Constitution is written as follows. In suits at common law where the value in controversy shall exceed $20, not $30, not $10, but $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So what's kind of interesting is that this amendment isn't that relevant today. I mean, it's in the Constitution, but basically today civil cases are not heard in the federal courts, and this has not been this amendment has not been applied to the states here. So unlike a lot of the other amendments in the Bill of Rights or portions thereof, the Seventh Amendment never was incorporated and applied to the states. However, the states basically have voluntarily given the right to jury trial. So even though specifically as applied to the wording, the Seventh Amendment only applies to the federal government, states have basically given its citizens this right to a jury trial, even though it's not really necessarily embedded in the Constitution, because this only applies in the federal courts. States have voluntarily, given individuals this right to a jury trial. Now, to me, when I've always read the Seventh Amendment, I've always been, the one thing that's puzzled me has been controversies that shall exceed $20. I'm sure the founding fathers must have known that in the future, $20, wouldn't really be worth as much as it was back then. And so there really is a mystery surrounding the $20 clause. But most scholars believe that amount would be phased out due to inflation. So it was put in there with the idea that, maybe the value of the amount. And basically today, suits will not be heard unless the amount is $75,000. So that $20 clause. So, if you sue if you sue someone for $50, you're not necessarily going to get a jury trial because of this $50. Okay. The Eighth Amendment, this one's a fun amendment, definitely. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So that's very controversial. What is cruel? What is unusual? I just read an article today before filming this lecture about Wyoming wanting to reinstitute a firing squad. You don't hear a whole lot about firing squads in terms of execution. You hear a lot about lethal injection, maybe the electric chair, or even death by hanging has probably been more common. But Wyoming, the idea of firing squads, I mean, just from a practical standpoint, it would probably cost a lot less to execute criminals through a firing squad. And actually, the Supreme Court hasn't really ruled that it's unconstitutional. It might be something that hasn't been used in quite some time, but the firing squad really hasn't been considered a method that's cruel or unusual as stated by the Supreme Court. But basically, the Eighth Amendment was inspired by an English case in which Titus Oates, he was guilty of perjury. Basically, he made false accusations, which ended up causing execution. So basically, people were executed. So he was found guilty of this. So he did commit a crime. Now his sentencement was imprisonment, actually for life. He was actually released 3 years later. An annual ordeal of 2 days pillory, being pelted with eggs, and then a third day whipped while tied to a moving cart. So this was, I mean, back in those days, that was the way to, publicly humiliate an individual. And even today, any version of this would probably be considered cruel and unusual. But to prevent situations like this from happening, the founding fathers thought it would be a good idea to have an amendment to the Constitution that prevents cruel and unusual punishment. And pillory, that's probably fall under more cruel, and being whipped while tied to a moving car, that's definitely unusual, right? Again, two court cases that you want to know here: Furman versus Georgia, 1972, and Miller versus Alabama, 2012. So that's probably more recent than a lot of your textbooks may have. So these are some court cases that might be helpful when you're trying to associate with the Eighth Amendment. Now, what is Furman versus Georgia? So this is the death penalty amendment. So the Supreme Court ruled that no arbitrary, cruel punishment that degrades human dignity can be applied to criminals. And they had a problem basically saying that the consistency in death penalty application, that it wasn't there. So they basically said, the application for death penalty, it was pretty random, and so basically it didn't call for a ceasing of executions. But from 1972 to 1976, it led to a moratorium on capital punishment until 1976. So it was a de facto moratorium. So because the Supreme Court said that the way that the death penalty is being established, it basically put an end to all death penalty executions, at least for 4 years, right? And so that was kind of the effect on that. So it was a very influential Supreme Court case. Miller versus Alabama. So this idea of cruel and unusual, the Constitution is silent on the case of minors. Well, what if a minor commits a crime? And what has been established is that, minors may not exactly understand as a full-grown adult the consequences of his or her actions, and therefore to punish a minor to life without the possibility of parole would be considered cruel and unusual. So in Miller versus Alabama, basically mandatory life sentences without parole, it cannot be punishment for minors, even for murder. So if a 10-year-old commits a murder, a judge cannot sentence life without the possibility of parole. So a life sentence is still permissible, but the idea that parole is still a possibility makes it not cruel and unusual. So what is cruel and unusual? It's probably left there to be intentionally vague so that the courts can hash out specifically. But there are definitely guidelines on what is considered cruel and unusual. Now, the Ninth Amendment. Ninth Amendment basically says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Again, this isn't the most oftenly cited amendment to the Constitution, but this was thrown in there basically to give you the idea that just because the right was not listed in the first 8 amendments doesn't mean that the right doesn't exist. And in fact, Justice William Douglas joined the majority opinion in Roe v. Wade, which was made in 1973, that there was a federally enforceable right to privacy in the Ninth Amendment's reservation of rights to the people, and that was enough to encompass a woman's decision whether or not to terminate the pregnancy. So as it stands today, Roe v. Wade is currently the law of the land. Again, it passed by a 5-4 vote, so there's no clear consensus even on the Supreme Court today. But this idea on a woman's right to her own privacy, actually, that's included. The idea of having an abortion is included to the right to privacy. So that's exactly what the Supreme Court has concluded. Now, there are mostly conservative justices that think that is absolutely reprehensible. But that is currently the law of the land according to Roe v. Wade. But this Ninth Amendment really is the idea of a general understanding that rights listed in the first 8 amendments is not an all-encompassing list of rights. And some have argued that we have a set of rights yet to be discovered. So maybe, a right for future technology 50 years from now, we didn't know we had, is there. And that no constitution can specifically list all the rights. It's too exhaustive of a list to write down. So if it required the founding fathers to write amendments listing out all the rights that we have, you can argue there can be an infinite number of things that we have the right to. So to kind of avoid that issue, we added the 9th Amendment, saying that there are other rights that are not listed. And the 10th Amendment, I guess, kind of goes along with the 9th Amendment, but it's that the power is not delegated to the United States by the Constitution, rights that are specifically enumerated, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So this is the idea that, yes, there are rights out there. There are rights out there that's not listed. And if the rights out there are not listed, then it's up to the states to determine certain things, right? And so that's basically this concept of federalism. So the 10th Amendment acknowledges that we don't have just a national government. We have a federal system of government that's with the states and the national government. And if the power isn't given to the national government, then that power is reserved to the states. In the 20th century, the Commerce Clause has been used to justify the use of the federal government's power. So the trend has been over the 20th century to give federal government a lot of power at the expense of giving the state the power. And so that's been the trend over the 20th century. But one court case that you can actually establish that goes against that trend is United States versus Lopez. Whereas most court cases, most Supreme Court decisions basically allowed for the federal government to gain more power and exert their influence more, U.S. versus Lopez actually asserted the opposite. So it actually cited basically the reasoning of the 10th Amendment, that the exception to the rule of more power being granted to the federal government, that's basically what they argued, that in this case, the federal government was overextending its authority. And in this particular case, what happened was that the federal law mandating a gun-free zone, the Supreme Court struck it down because there's no clause in the Constitution allowing its power. There's nothing in the Constitution that specifically enumerates the Congress to regulate guns in schools. So this gun-free zone was declared unconstitutional. Obviously, Congress passed it, so it must have been popular, but guess what? It was unconstitutional. Now, the dissenting opinion argued that Congress had the indirect right to regulate guns in schools. So, according to the dissenting opinion led by Justice Stevens, he argued that no, there's nothing in the Constitution that allows the Supreme Court to regulate guns in schools, but it has, under the Commerce Clause, the right to regulate commerce. And this is the line of reasoning that the dissenting judges used. An individual goes to school. You go to school for what purpose? Well, you go to high school to go to college, right? And you go to college, you learn a trade or you learn something so that you can get a job. And you get a job and you're eventually going to make money. And when you make money, you engage in trade. You engage in commerce. So because the commerce starts in school and that leads to a chain of events in which you eventually participate in commerce, Congress therefore has the right to regulate guns in schools. So that was the dissenting opinion. And but the majority basically said that no. This line of reasoning is way too indirect. It's way too loose. Congress has overextended its powers. If the state wants to make a law like that, then that's absolutely fine. But the national government, it's extended its powers. It's violated the 10th Amendment, that any rights not given to the federal government specifically is given to the states. Okay, so example number 1 here. So here's a question. Which constitutional amendment explicitly provides an individual with the right to privacy? So let's take a look. Which amendment says you have the right to privacy? So let's review these answer choices. First Amendment. So as far as I know, First Amendment has to do with religion, speech, press, right to peaceably assemble, and petition the government. So that is, there's nothing about privacy there. Second Amendment is the right to bear arms. Okay, well, that's not in there. The Ninth Amendment, any right not listed in the first 8 amendments doesn't mean that it's not a right that you have. There's no specific mention of privacy. And the 10th Amendment, any amendment that is not given to the national government is reserved to the states. There's nothing about privacy there. And so the answer here is that it's none of the above. There is no explicit right to privacy. Again, there is an implicit right to privacy, maybe under the 9th Amendment and maybe under the 3rd Amendment, but there is no explicit text in the Constitution that gives an individual the right to privacy. It's just simply not there. Okay, example number 2. What court case ruled that the death penalty was constitutional because it was imposed based on the circumstances of the case? Okay, this one's a little tricky. I did not go over this, but hopefully you're going to be able to use some logic to find the correct answer here. Okay, Furman versus Georgia. If you don't remember Furman versus Georgia, the one thing I do want you to associate with is that it was dealing with the death penalty. So you don't want to rule this out here, so you might want to put a little asterisk here as being a possible answer. Roe v. Wade dealt with the right for an individual a woman to terminate her pregnancy in the first trimester, and that has nothing to do with the death penalty. So B is wrong. Mapp versus Ohio. Mapp versus Ohio dealt with the exclusionary rule. So basically, it said that evidence obtained as a result of improper search warrant or illegal searches is not acceptable. The fruit of the poisonous tree. Okay. Gregg versus Georgia. Well, you can't rule it out. No, don't necessarily know what that is, so you might want to put asterisk in there. Wolf versus Colorado. That actually allowed evidence that had been illegally obtained to be used in the court of law. And so that, again, has to do with the 4th Amendment, so that is incorrect here. Now, again, going back to Furman versus Georgia, what this did, it ruled that the death penalty was unconstitutional. Ruled unconstitutional the way it was applied arbitrarily in different states. So it led to a de facto moratorium for 4 years until 1976. Aha! In 1976, it deals with a court case with Georgia. And so Gregg versus Georgia is the correct answer, because what it did was it basically reinstated the death penalty, because as long as there is a specific standard by which a death penalty is implemented, it's okay. So in this case, if you specifically didn't know this court case, then you could infer that if you add 4 years, and it was another state dealing with Georgia here. So the key is knowing, if you know a lot of these court cases, then by the process of elimination, you can, with a high degree of probability, come across the correct answer, even without knowing the specific merits of a case. Okay, example number 3 here. Let's take a look at, in Powell versus Alabama, 1932, the court established the due process clause of the 14th Amendment, guaranteeing defendants in death penalty cases the right to an attorney. What court case granted those unable to afford an attorney the right to one provided by the state? So in 1932, Powell versus Alabama, it only gave you the right to an attorney if it was a death penalty case. So it's kind of a narrow amount of individuals that had this right to an attorney. Let's take a look here. The first choice is Miranda. This one's very tempting here, so let's get back to, we know this has to do with something related to rights here. Okay, Wisconsin versus Yoder. So if you recall Wisconsin versus Yoder, this has to do with freedom of religion. So this had to do with 8th grade Amish. So up until the 8th grade, compulsory education was required. But after that, based on your religious views, you can stop going to school. And so this has nothing to do with affording an attorney. Engel versus Vitale. Well, remember, it is vital that you know this. It is vital that a public school teacher may not lead a voluntary prayer, even mandatory or voluntary prayer in the classroom, because that would establish religion. That is incorrect. Okay, Betts versus Brady. This one's a little bit, you haven't gone over this, so is this possibly the answer? So you can't really rule this out here. Again, Gideon versus Wainwright. You're not sure about this here. Well, you can eliminate Miranda versus Arizona because Miranda rights doesn't deal with an attorney. It just says that you have the right against you have the right against self-incrimination, and so these Miranda rights are given to you, but it doesn't necessarily say that if you can't afford an attorney, one will be provided to you. It says you have a right to an attorney, but it's not as specific here. Gideon versus Wainwright, that's the correct answer because basically an individual who is accused of burglary, stealing change from a soda machine, and he was convicted and sentenced to what he considered an excessive amount of time in prison. And the reason why he objected, he wrote an appeal to the Supreme Court saying that he did not have proper representation. He couldn't afford it, so he represented himself. So as a result, Gideon versus Wainwright, if you do not have the ability to afford an attorney, basically the provision is that the state is going to provide you with an attorney. And the final example here, kind of as a review to wrap up the Bill of Rights here, list the entire Bill of Rights, Amendments 1 to 10. So this is a good way to kind of test yourself right now if you know this or not. So you might want to pause right now and on a sheet of paper, write down the 10 amendments to see if you got this right. Again, brief phrase or sentence, no crazy long responses. This is a way to kind of sharpen your mind so that you know your civil rights here, okay, or civil liberties. Okay, so amendment number 1. So let's go with amendment number 1. So you have the 5 freedoms. And what are the 5 freedoms? And in the right order, you have the freedom of religion. And again, freedom of religion can be broken down into Establishment Clause, where the government cannot establish a religion, and also the Free Exercise Clause. So you can worship however you want, except obviously there's going to be some restrictions. You have the freedom of speech. Okay, now speech can be restricted. You can't yell fire in a crowded building. You might be liable. You have the freedom of press. You can print whatever you want. There's in a school setting, you might not have the liberty to do everything. And there's freedom of assembly, which the government has the right to restrict. And then you have the right to petition. There are certain things you can't do if you make death threats to the President of the United States and you write down a letter. There are clearly some restrictions about petitioning against the government. But these are the 5 freedoms found in the Bill of Rights here. The second one is the right to bear arms. Now, does that entail being able to own an AK-47 in your house? Again, some justices would say whatever gun you're permitted to have. Remember, the Supreme Court has ruled that you have the right to own a handgun, but that's limited to federal enclaves. Okay. The third one, again, is quartering the right against quartering soldiers. So again, if Obama comes knocking at your door asking if troops can stay at your house, you have the right to say no. Okay. The Fourth Amendment is the right against, and then this is the key here, unreasonable search and seizure. So unless a police officer has a warrant, it cannot search you unless there's a probable cause. For example, if you're walking down the street and you're drunk and you smell like marijuana and there's a bag of marijuana hanging from your pants, the police officer has the right to, through probable cause, to search you and arrest you for possession of that. Now, again, if it's just a random search, then that's a different issue. The Fifth Amendment has to do with the rights of the accused. Now, what are the rights of the accused here? The rights of the accused is, grand jury, double jeopardy, self-incrimination, right against self-incrimination, and then again, the idea of due process, that you're going to get a fair trial. Okay. The Sixth Amendment has to do with the right to speedy and public trial. Again, there are definitely restrictions. Again, usually, as a rule of thumb, less than a year. Obviously, some high-profile cases will take a little bit longer, maybe change the venue, stuff of that nature here. The right to civil trial by jury. So the idea that, prosecutor can't just try you and then, you're still in a civil trial, a jury is still going to be required. Again, it's not been applied to the states, but the idea of this taking place, states have kind of voluntarily given its citizens this right to jury trial. Eighth Amendment is the right against cruel and unusual punishment. Now, what is cruel and unusual? Lethal injection. Some of my people say that's really cruel. The electric chair, is that cruel? I mean, you've had cases where individuals have been executed through the electric chair and things that haven't really worked right. Death by firing squad, I mentioned earlier. Some people might say that's cruel and unusual. Hanging, the way that, what some person might consider cruel and unusual, it varies, and the standards can change, and contemporary standards. So this is something that I think most Americans agree that the death penalty for the most part is something that is permissible, but cases where you're dragged into the street, I think most Americans recognize that this is a constitutional right of being protected against cruel and unusual punishment. And ninth is unenumerated rights still exist to the people. So just because the right to raise my hand, do I have the right to raise my hand? Well, it's not in the Constitution. Well, just because the right to raise my hand is not listed doesn't mean I don't have that right. How about the right to use the internet? Well, the Founding Fathers would never have been able to predict that technology, but the right to maybe use the internet, that could be considered freedom. And again, the right to privacy is something that has been used to justify abortion, the right to privacy. So there are different things that could be used via the Ninth Amendment. And finally, the 10th Amendment is powers not given to national government is given, or a better word is reserved to the states. Again, one thing that you want to know with the 10th Amendment is that the general trend has been that the national government has been given supremacy over the states in terms of when there's conflict. However, there's certain cases where, states have actually won in terms of it's not the business of the national government. The most notable case being the U.S. versus Lopez and the act that Congress used to not allow guns in school zones. The Supreme Court ruled that Congress had overextended its authority, and the Commerce Clause did not apply to that particular situation. Thank you for watching educator.com.